Good afternoon, everybody. Welcome to another question and answer session live. My name is Samara Belitzky, and I'm an employment lawyer at Samfiru, Tumarkin. I'm working out of our Ottawa office, but I do assist employees in Ontario and in BC. So I will be here for the next 30 minutes to answer all of your questions related to employment law, employment issues, workplace issues, whatever issues you may be having related to your workplace, whether it's a termination regarding a severance package, whether it be changes that are being made to the terms and conditions of your employment. That was something that we talked about a lot in my last session, and we got lots of questions about that issue. It seems to be a bit of a hot topic. So if you are somebody or you know of somebody who is having changes made to their terms of employment, their pay, their hours, their job position, whatever the case may be, happy to answer those questions as well. I'll get us started while we're waiting for some questions to come in. I am hoping one of these days I can start this session without talking about mass layoffs, but unfortunately every single week we seem to be having more and more of these mass layoffs or mass terminations. So I will start off once again by talking about that because it's something that we're getting a lot of questions about. And I want to make sure that we give a bit of information. So if you are impacted by a mass layoff or a mass termination, or you know somebody that is, what's important to know is that it will impact what your bare minimum severance or termination entitlements will be. So when we're talking about a mass layoff or a mass termination, for example, in Ontario, that means that more than 50 people, or at least 50 people or more, have been let go at the same time. And so if that is something that occurs, there are special rules that are in place that actually impact somebody's bare minimum termination entitlements. So it's not that it will change somebody's full severance entitlements, and most people will be entitled to their full severance, which will be based on things like your age and your length of service, among other factors. But when we're dealing with a mass layoff or mass termination, your bare minimum entitlements can be different and would be different than if you were let go, on your own as an employee, or if only a few employees are let go at the same time. Anything under 50 essentially would not be a mass termination. 50 or over would be in Ontario. So if you're being let go as part of that, your bare minimum entitlements, your starting off point under the Employment Standards Act, will be more than what it would normally be if you're let go on your own, not part of a mass termination. That's the real difference when it comes to your termination entitlements when we're dealing with a mass layoff or a mass termination. Other than that, your full severance, again, I'm just talking about your bare minimum entitlements being increased, being more than what they would otherwise be, but your full severance as an employee will still be the same. So just because it's part of a mass termination, maybe the company is going through financial difficulty, the odds are that the company is experiencing financial difficulty if they're going through a mass layoff, laying off, a huge percentage of their total staff. If that's happening, that doesn't mean that you're owed less severance because it's, a result of a financial difficulty from the company. That won't impact how much severance you would be owed. So it's really important to keep that in mind. If you are someone you know is impacted by a mass termination or a mass layoff, your full severance entitlements will remain the same. They won't be impacted by the fact that it's a mass termination or a mass layoff. They won't be impacted by the company's financial status or difficulties. Now, a company's ability to pay might be impacted, but from a legal perspective, somebody's full legal termination entitlements, your full severance, would not be impacted by those things. And so it would remain the same, as I mentioned before, based on things like age, length of service, your position. So there's different factors that we look at, but that's what it would be based on, more or less. So really important to keep that in mind in terms of moving forward. If you are somebody who's let go, or you know somebody who is, whether it's an individual termination, maybe you're one of 10, maybe you're one of 2, or you're part of a mass termination, maybe you're one of 2,000. It doesn't matter in terms of your full severance. You're still owed, if you're owed your full severance, it doesn't change. You have to get your package reviewed by a lawyer before you sign or agree to anything. You may feel that, whatever you're presented with is all you can get and it's all you would be owed because that's what the company's offering you, or they might be saying that they can't pay you much more, they're going through financial difficulty, whatever the case may be, you should not allow yourself as an employee to be pressured into signing something on the spot, and certainly without getting legal advice. Even if you decide at the end of the day you want to accept the package that was offered to you, it's very important to get it reviewed by a lawyer first. Do your due diligence, and then you can make a decision, because most often than not, you're not going to be receiving or being offered what you should. So as an employee, it's really important to get your package reviewed, get everything reviewed by an employment lawyer. Make sure you know where you stand, what the law says about your situation, what you're owed compared to what you're being offered, and then you can make an informed decision on what you want to do, because most of the time you will be owed much more than what you're being offered initially. And so it's really important not to sign anything until you speak with a lawyer. Once you sign, you're stuck with it. There's nothing else you can do after that. So that's why it's so important to make sure that you educate yourself, you speak to an employment lawyer. There's different ways of contacting us. You can go to employmentlawyer.ca. All of our contact information is there. My contact information is there. You can always contact me directly to take a look at your severance package and see how it compares to what you're owed at law. Okay, we have a bunch of questions coming in, so I'm going to get to the questions. I have a question from Bob on YouTube, who says he's getting workers' compensation and trying to get SSDI. Will that affect my workers' comp? In terms of the SSDI, if you can just be more specific, Bob, send me another message here and let me know exactly what you're talking about in terms of what you would be receiving. But generally speaking, when you're receiving workers' compensation, it's basically an insurance scheme. So in Ontario, it's the WSIB, Workers' Compensation and Insurance Safety and Insurance Board. And so when you're receiving benefits from the WSIB, when you're receiving workers' compensation benefits, they are loss of income benefits. They're income replacement benefits. So similarly, if let's say you were getting disability benefits from a short-term or long-term disability provider, if you were on LTD and you were receiving monthly disability benefits from LTD, it's the same kind of thing. It's all income replacement because you're unable to work because of a medical condition. And so when you receive other types of employment income replacement from other sources, for example, if let's say you were to get EI benefits, if you were to go and receive, let's say you're let go during that leave, even though by law you're not supposed to be, but if it does happen and you receive severance, that's also income, employment income. So anytime you're receiving any sort of employment income from other sources, the insurance company or the WSIB or the workers' compensation scheme that you're participating in, they have the ability to claw back the amount of benefits that you're receiving by the amount that you're receiving from other sources. And the most common one would actually be CPP disability. That's a federal benefit that a lot of people will be able to have access to. If, for example, you're on a medical leave and you're on LTD, you're getting disability benefits, and then you're getting CPP disability at the same time, then the insurance company will claw back your benefits by the amount of CPP disability benefits that you're receiving, so that the total that you're receiving is never more than the total that you should be receiving from the LTD provider each month. It can be a little complicated. I hope, Bob, that that's making sense to you. I see your other message here, weekly benefit and a settlement. Okay, I'm not quite sure what you mean by a settlement. So if you'd like to discuss this further, I would actually recommend that you contact me directly. You can find my email address on our website at employmentlawyer.ca. Click on my profile, my email's right there. You can send me an email directly, and we can discuss further through a consultation, because it's not clear what's happening here, and these situations can be complex. So if you're entering into any kind of settlement, you really want to make sure that you're having a comprehensive consultation with a lawyer about all of the components of what's going on and how that may impact your workers' compensation, because certainly there is an interaction there. There's a connection there. One will be impacted by the other in most cases, but I have to figure out from you, Bob, what exactly is the settlement that you're talking about? From who, what is it for, and then we can figure out how that could impact your workers' compensation. So reach out to me separately, because generally speaking, there will be an impact, but we have to look at it a little closer to see what that might be. I have a question from Tristan on Facebook who asks, can a manager tell you to remove posts from your private social media accounts? The answer is it depends. It depends what's in your post. If you've posted something that is, runs counter to what you would have to be representing as an employee of the company, they may be able to ask you to remove certain posts from your social media account. Another factor would be whether you've signed a policy. A lot of employers these days will have policies about social media use, and they may prohibit posting about the company or posting about topics that relate to your employment or to the business that your employer is in. So if you've signed a policy saying you're not allowed to do XYZ or not allowed to post about XYZ, and then you do, you'd be in breach of that policy. So that, number one, could be misconduct. And then the employer certainly would have the ability to ask you to remove it. If there's no policy in place, it is more of a case-by-case basis where, like I said before, if you're posting something that's, inconsistent with your duties at work, if you're, disparaging the company, bad-mouthing the company, there are certain situations in which it can be considered misconduct, and a manager or employer can ask you to remove those posts. So it really does depend on the situation. If you want to, provide us with more information or contact me directly to let me know exactly what the posts are about, we can talk about where you work and what might be inconsistent, because the reasons for having you take it down, as well as what you actually posted, will be determinative of whether they have the ability to ask you to take it down or not. And then furthermore, if, let's say, you don't take it down, there could be discipline that is applied. So you have to be able to find out first, Tristan, if this is considered misconduct. If it is, they have the ability to ask you to take it down. They have the right to do it. And then if you don't take it down, that could lead to further issues, further discipline. It could possibly lead to a termination of your employment, even for cause, meaning that you've engaged in intentional misconduct, and you would be able to be let go without any notice or any severance. So I would take this situation very, very seriously. If any of what I'm saying kind of applies to your situation, definitely get in touch with us. You'll want to make sure that we go through your situation with you, from top to bottom, talk about everything, and we're able to give you a more comprehensive legal opinion before you do anything. Before you refuse to, let's say, remove the post, you should make sure that you know what the law says about your situation, and if there could be further discipline applied to you for either posting whatever it is that you might have posted, or refusing to remove it. So there's kind of two issues at play here. So I would recommend that you get in touch with us so that we can discuss this further with you and give you more comprehensive advice. I have a question from Candace on YouTube who says, my husband has worked for the same company for almost a decade without signing a contract. The company is now being taken over by a new owner, and they're asking him to sign. Does he have to if his job is the same? Great question, one that we get all the time. I have consultations with people in this situation all of the time. The short answer is no, he doesn't have to sign, okay? Now, the kind of long answer is if he doesn't sign, they do have the right to let him go, because an employer does have the discretion and does have the right to let an employee go at almost any time and for almost any reason. And that includes somebody's refusal to sign a new employment contract. I always advise people, whether you have the same company, there's no sale of the business, it's just the same employer, but they decide, 10 years in, they're going to present you with a new contract, an updated contract, or a contract for the first time. whether it's in a situation like that, or whether it's a sale of the business where a new company comes in and they want everyone to sign a new contract. Whatever the case may be, if you're an employee being presented with a new contract, you should be getting it reviewed by an employment lawyer before you make any decisions. Whether you decide to sign it or not, you need to do your due diligence. Make sure that you understand what it is that the contract actually says, what it will do in terms of your terms and conditions of employment, in terms of your severance entitlements. That's a big issue in terms of new contracts. Oftentimes, new contracts means that your severance might be impacted. You might be agreeing to limit your severance entitlements by signing that new contract. That's why it's so important to speak with an employment lawyer and find out exactly how this would apply to you before you sign it. And then you can decide whether you're going to sign it or not. A big consideration, of course, would be, if you know that the employer is going to let you go if you don't sign, you're going to want to think about that long and hard. But generally speaking, you don't have to sign. As an employee, you have the right to refuse to sign. You can't be forced. So what I would recommend, Candace, for your husband is that he should get in touch with us. We can review the contract with him, go through it, make sure he understands, what the changes might be compared to what his employment is now, what the terms would be moving forward, if it impacts his severance entitlements, what he would be giving up if he decided to sign. He should know all of those things before he makes a decision, and then he can decide if he wants to sign it or not. But he certainly should not sign anything without speaking to a lawyer and getting it reviewed first, because he doesn't have to. Okay. So certainly if, he can contact me directly, or any of our other lawyers, he can email help@employmentlawyer.ca, or he can email me directly, and we can set up a consultation to review the contract with him so he knows where he stands. Because 9 times out of 10, when we're seeing a new contract, it's not a good thing for the employees. It's usually to protect an employer. As an employer, it's something that, an employer should be doing to limit their own liability. On the flip side, as an employee, it's usually just beneficial for the employer and not beneficial for the employee. So you have to be very, very careful as an employee not to sign anything unless you get it reviewed first. I have a question from Emma on YouTube who says, my job is moving internationally. The company is offering to place us in new roles, but I would like to decline. Is there a penalty, and will I qualify for severance? Okay, so generally speaking, an employer cannot make unilateral changes, meaning forcing changes on an employee without their consent, if there's significant changes. So oftentimes we talk about changes to your job. If you're a manager, sometimes it's a demotion, sometimes it's a reduction in your salary or your compensation. But here what we're talking about is a move, right? A change of workplace location, which we do see sometimes where, a workplace might move a few hours away. So generally, an employer cannot force you to a new workplace that is of a significant distance. So if, let's say, it's an extra 20 minutes of a commute each way, that wouldn't be a significant enough change. But if, let's say, it's another hour to your commute each way, an additional hour, that would be a significant change, and they can't force that on an employee. An employer would require an employee's consent for that. Similarly, if you say they're moving internationally, Emma, I take it from that they're probably moving to another country, which certainly would be a significant change. So if it would require you to actually move to another country, certainly you do not have to accept that. You have the option. You might decide that that's something that works for you, and you may decide to accept that offer and move. But you don't have to. You don't have to accept that change. You can insist on not moving. Now, if, let's say, you play this out, Emma, and you decide you're not going to move, like you said, you want to decline, you can decline. If they're moving their entire business operation internationally and you decline, that means there's no job left for you, which is a termination. And so either they're going to outright terminate your employment, a without cause termination, meaning a regular termination where you're owed your severance, or if they don't terminate you without cause and offer you severance, which is what they should do, If they don't and just say, well, you declined the job, so you're resigning, that's still a termination, which would be called a constructive dismissal. Because even though they're not saying outright to you, you're fired, you're terminated, the end result is the same, because they're making it so that you can't continue your job as you currently know it under the same terms and conditions working here. They're essentially moving their operations so that you can't continue working. So that is akin to a termination. It's called a constructive dismissal. So whether they actually say to you, okay, we're letting you go, here's your package, or they consider you to have resigned, in both scenarios, it still is a termination and you would be owed your severance. Okay. How much severance you're owed will depend on things like your age and your length of service. Certainly, you can always contact me and we can go through that with you. For the time being, I would say you're okay to go ahead and decline, and then you see what happens. If they offer you a package, just like I mentioned earlier, get in touch with us so we can review it before you decide to do anything, because you need to see, what it is they're offering you versus how much you're actually owed. And then if they don't offer you a package, if they say, you've abandoned your job or you've resigned because you don't agree to move to another country, get in touch with us at that point as well. Because like I said before, that would be a constructive dismissal and you would be owed your severance, which we can assist you in pursuing. All right. So Emma, hopefully it goes the first way and you can certainly just negotiate a severance package, but either way, we can assist you. Don't hesitate to get in touch with me. Okay, I have another question from Angelica on Facebook, who says, I was recently demoted from a supervisor position. I had no warnings or performance reviews on my file. No corrective measures were put in place to correct potential performance issues. It comes with a reduction of hours and reduced rate of pay. Can they do this? So I'm going to go back to what we were just talking about in terms of changes to your job, changes to the terms of your position. So when we're talking about these changes and the fact that an employer can't make significant changes without an employee's consent, certainly one of those things is a demotion. So in other words, an employer cannot demote an employee without their consent. Now, there are exceptions to that, and it is when the demotion is done for disciplinary reasons. And what that really means is, if let's say you're in a supervisor or managerial role and you're not performing up to the standards that the company expects, they provide you with multiple warnings, they work with you, they put you on a performance improvement plan, they try to help you get to that point, but it's not working out. In some of those situations, the company could possibly be justified in moving forward with a demotion without the employee's consent. There are few and far between those situations. They're very exceptional, but I wanted to just outline that because that is something that, can occur. In this case, Angelica, if you haven't received any warnings, just all of a sudden you are demoted, no, the company's not allowed to do that without your consent. It sounds like you've been demoted and your pay has been reduced as well. So you have two issues here, two changes that are being made. When it comes to pay, it has to be a significant reduction. Generally speaking, in order for it to hit that threshold of it being significant, your overall annual compensation needs to be reduced by about 15% or so. So if that's the rate or the reduction percentage that you're seeing here, Angelica, that's a problem as well, that your pay is being reduced. But either way, a demotion out of the blue, no warnings, not for performance issues, just because maybe it's financial reasons, I don't know what the company's reasons are, whatever the case may be, they're not allowed to do that. That would be a constructive dismissal. And you would be able to treat it as a termination and go after your severance. So get in touch with us. The thing that's important to keep in mind when we're dealing with constructive dismissals is that time is of the essence. I cannot stress this enough. The worst thing that I deal with sometimes is I speak to somebody who had changes made to their terms of employment. They worked for 6 months under those changes and then decided they didn't like it and wanted to do something about it, but it's too late. You have to move on these things quickly. You have to seek legal counsel. and express your refusal right away. You cannot keep working under the changed terms of conditions and then decide later on that you don't like that and you want to do something about it, because it will be too late. You will be in a situation that's called a deemed acceptance. So even though you haven't specifically said, I accept these changes, you haven't signed anything that says that, just by continuing to work under those changes, you will be deemed to accept them. And then that's part of the terms of your employment moving forward. So Angelica, I don't know when these changes happened, but you should get in touch with us right away. You need to move on this very, very quickly to express your refusal, to make sure it's understood that you don't accept these changes. And then you will be in a position where you can treat it as a termination and go after your severance. Okay. And for anyone who is watching who might be in a similar situation, again, I cannot stress this enough. If there are changes being made to your terms of employment, you need to speak with a lawyer right away. You need to figure out if the changes are lawful or illegal. If there are changes that are illegal, if there are significant changes that the employer can't push on you, can't force on you without your agreement, you need to move forward on refusing it right away with the help of an employment lawyer. So keep that in mind. Time is of the essence. You have to move quickly on these things. Okay. I know I have a lot of questions here. I'm trying to get to as many as I can. I have a question from Janice on YouTube, who says, I got crushed by lockers at work last year and I'm disabled for life. I'm really sorry to hear that, Janice. Now WCB, so workers' compensation, is pushing me to go back to work and learn to live with my pain. Can I sue the company for negligence? Okay, so generally speaking, when you have a workplace injury and you work at an employer, a business, or a company that has workers' compensation coverage in the province that you're in exchange for having that coverage, the employee is not able to sue the employer directly for the workplace injury. So essentially, you're part of the insurance scheme with workers' compensation in the province that you reside in and you work in. And you can file a claim and you will have coverage if you have a workplace injury. They will provide you with the benefits that are required. If, let's say, the employer is at fault, the injury was preventable, the employer did not follow the law, maybe they were negligent, the workers' compensation board in the province in which you work has the ability to sue them on your behalf. Okay, it's called subrogation. They can basically do the claim for you, and that's in exchange for this insurance scheme of workers' compensation. That's how it works. And so if there is a negligence at play, if there is something that the employer might have done wrong, usually there's a referral to the Ministry of Labor. They'll do an investigation. But generally speaking, if there's negligence at play for the injury, the workers' compensation lawyers will go after the employer on your behalf. So you can't sue them personally yourself. You would have the right to benefits as long as you continue to be unable to work. What you're describing, Janice, in terms of them pushing you to go back to work, so at a certain point, if let's say you can't go back to work to your own job, they will provide you with retraining and with courses and with assistance to transition to another career, to another kind of job, to go back to work if you're able to work at all. If let's say there are doctors that think that you can go back to your previous job, but with accommodations, that's also something that they might be pushing you to do. But keep in mind, if you have your own doctor who's saying you can't go back to work, or you're not able to work, or whatever the case may be, you can push back towards the Workers' Compensation Board. You can appeal their decisions. You don't have to necessarily agree with what they're telling you to do. As long as you have the medical to back it up, there are ways that you can request reconsiderations and appeal their decisions and push back. So that's something that certainly is worth looking into, Janice, in your case. If you have, a doctor who has a different opinion than what the WCB is saying. And then from an accommodation perspective, if you can go back to work, but you do require accommodation, then you would just have to provide a letter or a note from your doctor describing the accommodations that you require. And then the employer does have a legal obligation to accommodate your medical restrictions as long as it's possible. Okay. It's what we call up to the point of undue hardship. But essentially what that means is as long as it's not going to cost the employer a fortune to accommodate you, which would make it impossible, or there's some sort of logistical reason that would make it impossible. Short of those things, the employer does have an obligation to accommodate any sort of medical restriction, especially as it's supported by a doctor with a doctor's note. All right, Janice. So certainly, if you're having issues with that, you can get in touch with us. Hopefully that answers your questions. I know I have more questions here that I didn't get to. We're just at the end of our time here. So we do have another question and answer session on Monday. We have a bunch of them next week. So feel free to tune in then and ask your questions. Otherwise, you can always email us at help@employmentlawyer.ca or email me directly. My contact information is on our website, employmentlawyer.ca. You can email me and we can go from there. All right. So thank you everyone very much for tuning in. Thank you for all your great questions. And I hope that you all have a wonderful weekend. Bye.